Hey! Oh, ooh, Tuesday? Is it Tuesday? Is it Tuesday? It is Tuesday. What a day! What a day! What a day! What a day! Oh, we have new development in the 2001 cold case, the Georgia versus Faust. Charlie Adelson, oral arguments in his appeal. But we will start with the Karen Reed civil suit, the wrongful death civil suit, which is, well, it's the thumbnail. So I suppose that is why most of you are here. But we have three things to go through today. But we will start with the Karen Reed. It's a hearing. It's a Zoom hearing. And there's a lot of lawyers on there. Gee, wow. There's a lot of lawyers on it. So let me just show you. There's a lot of lawyers. Let's just say that. Oh. And with a lot of development. Hello, Divance Moore. Denise, just Stacy, Divance Moore, Age of Nefarious, Tammy Fayette, Tammy Bogard. There's a lot of Tammys here. Gwendolyn, I said it, Courtness. Hello, folks. Hello, folks over at X. Hello, folks over at Rumble. Yes, YouTube, Rumble, X. That is where I'm streaming today. Mr. Jingles was just here. And Mr. Penis is okay. Well, he's mad at me because I had to clean out gunk from, his the gunk that collects on the tear canal thingy. He did not like that. So he's plotting to kill me again. Well, he always plots it, but now it looks like he means it. Well, he always looks like he means it. But yeah, you know what? He's a cat. He's a cat. He's my cat. Love him to bits. He's an asshole, but it's mine. Yeah. The eye boogers are no fun. All right, folks. I just came over from Mo. I was there for the last few minutes. Apparently, they had this little thing called toolmark analysis. Toolmark analysis, if you haven't heard it, is a shit science. It is completely subjective. Folks, when it comes to gun barrels, to tools and everything, for instance, when they drill the barrel, that tool, about 2,500 barrels before they have to change the tool for sharpening and stuff like that. Meaning that roughly, if you find a gun with tool mark, that's roughly 2,500 other barrels that are basically identical. It's a shit science, and it has been so for a very long time. All right. But we are here for this. Let me put myself down. No, I'm covering. I don't want to cover anybody's face. Covering somebody's. I have to be out here in the corner. With this number of attorneys, I have to do this. Now, here is Mr. Rosenberg. He is the representative for the Karen Reed team. Down here is the courthouse. And then everybody has representation, which they should, but it's a lot of people. It's a lot of people. All right, folks, are you ready? Because we are going to hear something equally disturbing and not surprising and kind of fun. All right, let's see here. I have audio enhancing on.
I can confirm that we have.
Yeah, sorry, the stream started mid-sentence. Nothing I can do about it. Very factual lie.
Some very technical folks on our end that have been trying to access the documents for the same purpose of moving this case forward. And it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date.
Did you hear that? There's a lot of videos all of a sudden. Ring doorbell videos. Where did those come from? What's on it? Why haven't we seen it before?
In time-stamped, we're having a difficulty sort of trying to weed through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
What depositions, if any, have been noticed by CNC?
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Yeah, but where do they get all these wrong Dilberg videos from and everything? Now, the videos from the Karen retrial, yeah. But it seems like the DA's office here, even towards the McAlberts, says, yeah, let's just give them everything with no identifiable markers, even to the McAlberts. Now, why would a DA's office do that? That's a rhetorical question. Because they have shit to hide. They don't want them. Now, for the sake of argument, for the absolute sake of argument, or why do they hide it from the Reed camp? It's more important, why do they hide it from the O'Keefe, from Reed? Well, the DA's office don't want the truth out there. Of course, they will do everything in their power to be complete pieces of shit. Because they've been lying to the O'Keefes for years.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was for us to review the documents before starting that process.
Attorney Hassett, do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files and our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents assist with whatever technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that needs to in the next couple days to address any technological issues that are remaining.
So Attorney Rosenberg, in November, Attorney Waters indicated that the Reed team had sent out between 10 and 12 subpoenas.
That's correct.
And it appears you've resolved at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as the Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one. Sorry.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor.
Yeah. Having depositions when there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 attorneys. Yeah, scheduling is rough and will be rough. That's not the problem here is that Proctor has made himself unavailable for 6 months now. But things are catching up to Mr. Proctor, the former, now disgraced Trooper Proctor. But what Mr. Rosenberg here will talk about is in the center of this case.
And his counsel's availability, and that'll be going forward in April. We have not yet scheduled other depositions, but we from the Reed side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon as we're able to coordinate schedules, which has obviously been daunting in this case.
So just so I understand, what subpoenas have been sent out?
So we've sent 2 subpoenas to Michael Proctor because there was additional information that we became aware of. We've sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department. We sent a subpoena to the Massachusetts State Police, sent a subpoena to Sergeant Good, as Your Honor said. We sent a subpoena to, I don't know if I said the district attorney's office, but both us and the plaintiff sent subpoenas to the district attorney's office. We sent a subpoena to Mr. Proctor's prior attorney in connection with his appeal just related.
Yeah, they sent a subpoena to the attorney's office that was hired by the police union until the police union got aware of what was on Proctor's phone and made them drop him like a bucket of shit.
Getting to this one particular issue that is relevant to the district attorney's office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but that's the bulk of them thus far.
When did the subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So,
yeah, the town of Canton apparently told them this is all we have. And now apparently they have more. Now this might have to do with the town of Canton exchanging some of the pro-McAlbert people in the Canton Town Board to people with honesty, integrity, and morals. And these new people, now when they are in majority, now they can produce papers that the previous majority really didn't want anybody to know about. So the development in this case, and folks, it will take time. It will take time. But I feel like this civil case might be revealing more truth than the trials ever did. I have a feeling, because all of a sudden, as we heard earlier, Ring doorbell camera videos, where were those in the trials? Huh? Yeah. So I can't wait. Now, again, this is a civil suit. There are 11 attorneys here for different parties. It will take time. I'll be here for it.
In the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
The judge. I like this judge.
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer, as we're required to under 9C, to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena, because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So
between the time that he got his phone back and hired new counsel, he lost his phone. Oh no! What bad luck! Did he call Higgins for advice on how to lose stuff? Did he call the McAlberts? Hey, can you give me directions to these where you destroyed your phones? What bad luck that he just lost it. And I have here a reenactment on how Proctor may have lost his phone. Yeah, I think this reenactment is quite accurate. It's such bullshit. It's such bullshit. And here's what I sadly believe will happen is that the Karen Reed team now has to chase down the documents via first the DA's office, who I would not be surprised to say, no, after we left, gave the phone back, we destroyed it all. So now they have to chase down every criminal case that has been given and try to retrieve it that way. Now, in the grand scheme of things, because losing his phone and DA's office may or may not be destroying the evidence as well, in a civil case, that can be used against them. But I sure as hell want to see all of that shit that was in Proctor's phone. The information is out there, and as a last resort, we know that the FBI downloaded his phone in its entirety, including the cloud storage, as a last resort. So the information is already out there. Proctor and the DA's office is doing the best they can to hide it, destroy it. But it's out there. It's out there somewhere. It's just a matter of finding it.
But now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe...
Hi, Dave. No, it's Tuesday. Let's wait for Friday and a slightly bust Friday show. Then you can sponsor me as much as you want. But thank you for being a member for 17 months. Can Proctor flip sides now? Well, he can, but I don't think he can anymore. Not without implicating himself criminally. They will have to drag everything out of him. Everything. The moment of his flipping sides, I believe, ended with the second trial and the beginning of this civil this civil suit. He has nothing to lose. Well, his liberty. Because depending on what's on the phone and from the rumors and everything, there might be things in there to criminally implicate him in quite severe stuff.
relieve that frustration. If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This
A judge telling the parties in an 11-attorney panel time to submit to court. That does not come easy for the court. Usually, courts will tell the attorneys in a civil suit, you're adults, you're grown-ups, you have a duty to the court, get things moving. Now, the Karen Reed team, through Mr. Rosenberg, they have tried. They really have. And they are stonewalled. And now the court says, all right, time to get our hands dirty. The court allows the Reed team submit the motions. Let's get moving.
So,
This
can I
case
just be clear?
needs to start moving on.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them. And I'm simply suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools, and we'll continue to do so.
Anything else?
Not for me, Your Honor.
Okay, so why don't we all plan to get together next Thursday at 4 o'clock in the same fashion?
Next Thursday. The judge here. Yeah, let's move it along. Let's not wait another 2 months for the next freaking hearing. Let's gather next week. Which means that the Reed team, all right, let's submit some motions. And Proctor's attorney and the other attorneys, some of the other attorneys, oh shit, we have to motion eliminate the ever-living fuck out of this.
And Attorney Diller can report on his success or lack of success in seeking to access the documents, and it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question, though, about the request for the intended depositions. Are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose.
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right? Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
Thank you, Your
Okay,
Honor.
so for the
Thank
record,
you.
Your Honor.
for the record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produce to Attorney Diller.
Okay, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production
Okay.
came from their office.
All right. Thank you.
Your Honor,
Thank you.
Your Honor,
Yes, sir.
with respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to have it, to be able to receive it. Otherwise, we can't just, you will not be able to receive it just via email. You'll need some type of technical capabilities to receive the actual documents. So we're happy to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you all.
Yeah. So this civil suit, it's getting worse. Not for the Reed team. It's getting better for the Reed team because now the judge tells it out loud to the Reed team, submit the motions to the court, and I will compel every single fucker that tries to stonewall you. Well, not in those words, but that's basically what's happening here. 8 months stonewalled by the DA's office, the prior Canton Select Board, the Boston PD, individual cops, it's just stonewalling. And then you have Proctor losing his phone. You retard. Proctor, seriously. When you get called to testify in the civil suit and you have to explain to a jury of a bunch of normal people that you got the phone back from the DA's office, 4 to 7 days later, you hired a new attorney. And in between that time, you lost the phone. Mr. Proctor, barely functioning imbecile, who ruined the John O'Keefe investigation, making it basically impossible to ever indict any of the more probable murderers, plural. I mean, sometimes there should be, once it's proven that an investigator not by incompetence, because Proctor is competent. We've seen that in other cases he's handled, that he knows exactly how to conduct an investigation. This investigation here is not incompetence. It's him knowingly butchering it, willfully butchering it. And this is not legal in any way, shape, or form. It's just a wish from me that when an investigator willfully, knowingly botches a murder investigation, he should do the time instead of the murderer. Soon enough, Morrissey is soon enough out of the office. He will not. He claims he won't try to be re-elected. We have Mr. Deitch, who is running for office, and I hope he wins because he was involved in the Karen Reed investigation. Now, he can't use the information he has because of the federal investigation. He still knows what to look for. I hope he will clean house. So that was the Karen Reed update. And they will have a new hearing in a week. Well, next Thursday at 4 p.m. A Zoom meeting. Now, Charlie Adelson. Time to talk about Charlie Adelson. Charlie Adelson was convicted 2 years ago of the sort. Well, it is over 2 years ago. He is now up for appeal. And I secretly want him to win the appeal because I would love to see him after his mother's conviction where she threw him under the bus. Imagine what he will do to return the favor. Imagine what he will do. Imagine what he will do. So, folks, oral arguments in the Charlie Adelson appeal. Sadly, this as well, they started mid-sentence. The judge, as here, do not give a flaming fork. Oh, you're going to love this. Let's just start.
To determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause.
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require.
He got 30 seconds before he was interrupted.
Before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what?
Whoopsie.
Type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know. And my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure. But one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that, what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that This isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript, there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper.
That's an official answer to a submitted jury questionnaire. I turned off the propaganda box. That's the best answer in a jury questionnaire form I have ever heard. Oh, that's so. If you by any chance, the juror who submitted this, please come on my show. I want to talk to you. I really want to talk to you.
That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
So clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record, as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, Court TV, shows
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client was innocent.
I submit to you guys that the coverage on YouTube is probably better now than the media was in the 90s. And it's damn well better than media is today. Why? Because we don't claim to be unbiased. Now, this here, my little corner of the YouTubes, I am heavily biased towards the defense. There's no question about it. Even for Charlie Adelson. I need evidence. I need to see the proof beyond reasonable doubt. Now, I can have opinions that people are assholes. I still need proof.
We don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial. When you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? And certainly no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right. So specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, 3 actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
No,
Was there an
I
objection?
understand. But again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental error
Well, my
standard.
understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with the change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple.
Usually, I've been covering oral arguments in appeals court, Usually you get questions. You get some questions, and then they allow the attorney to speak. Oh boy, this Mr. Charlie Adelson's attorney, this is on his time slot. And they are burying him with facts.
Responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion. And they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved. And they did so under the fundamental error standard. And so I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure. Well, yes. But so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error.
Now, I have to say, Charlie Adelson's appeals attorney here is handling himself really, really good under the pressure of the appeal court judges. With the facts he has to work with, he's doing really, really good.
So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury? And let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
Well, it
fact.
sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal. And that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But but
are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting in my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll
Thank
do
you.
the same thing for the state.
Thank you. I appreciate that. I do need to address, so we have, and I've already talked about this.
That was very, very nice of the judges of the appeal court to extend the time, because they recognize, they really put this attorney through hellfire. But they also acknowledge that, you have more points to get to. So they gave him an additional 5 minutes. Yeah, nicely done. Nicely done.
The almost 40, or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that.
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse. And again, we can't presume that.
Let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court. Ask point blank.
Are we supposed to just assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those 2, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that, and going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number 1, that jurors have not followed the judge's direction. So much so that the judge, when he heard about this, after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know—
But the problem is the content of those communications. And they were like this: high-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the— and that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right?
Right.
So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty...
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the 2 jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C, on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the entire, that set of the panel. So we have 4 statements. Let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again. And the judge said, from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names. I apologize. I will say them.
Again, this attorney, this is vigorously advocating for your client. Now, I've seen oral arguments in appeals court where attorneys buckle under this type of pressure. This attorney just keeps going. This is good. This is good. And he's actually making a solid argument here that if the judge found out that, oh, somebody's been walking around claiming to this group of 50, guilty, 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 guilty. Is it enough to just exclude 2? It's actually a compelling argument here. Now, his problem is that prior counsel didn't raise it. So would this argument, now he's trying this avenue right now. There's also an argument for ineffectiveness of counsel. And if you remember the Charlie Adelson trial and his new sets of attorneys, they were horrible. Absolutely horrible. So he could have 2 avenues here. I'm wondering if he will address both.
It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty. But don't we typically, we're going to strike a panel, we'll require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually said.
But the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
Oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they were they weren't sure in the third group of 50 whether or not they were going to finish. The clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, you living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that has disclosed that they've been talking about the case and is getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors, and 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done. And because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes. And
8 minutes extra, because the court recognizes he needs the time, because they are interrupting him, they are hammering him, and he doesn't waver. I'm thoroughly impressed by this attorney, thoroughly impressed.
the same for the state, so you'll have a total of 8 extra minutes.
Thank you, Your Honor.
May it please the court. My name is Charlie Lee. I work for the Attorney General's office and I represent the state of Florida in this case. I'd like to start out with the questions the judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The 3 justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Ufferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner. And I know that that's where the Supreme Court first made this rule very, very clear. And they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel.
That would be hidden true crime audiences. Law and crime. And even law and crime and court TV, occasionally they have a case where people switch. That's the thing with hearing evidence. That sometimes even people who believe somebody is guilty change their minds. Now, that's not for the court, that's for the public opinion. But I'll give a recent example here. Me and Mo sat down for the Uvalde trial against the officer, thinking, fuck that guy. A day and a half into trial, oh, geez, they charged the wrong one. Mr. Guterres was the one cop at the Uvalde who actually tried to do something. Once actual evidence was presented, not the media narrative.
That will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where, you know, Mad Dog Irvin was in the press, as serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where
I like this appeals court. They are putting pressure on both sides. If you're going to show up here for oral arguments, you better have your shit together.
point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneermen, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree, Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know, there's no indication that this young man stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone. We don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue, or denial of a change of venue motion, or prejudice within the community, or biased amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there and McCaskill, there the courts that came long after.
I just want to remind people that if you just tuned in and wondering, this is not the Karen Reed hearing. No, first half hour, 40 minutes. Now we are got into Charlie Adelson's appeals, and the next case we are covering is the 2001 cold case in Georgia, in Clark County, where the prosecution submitted evidence bags where the evidence wasn't in the bags. So once we are through with this, the Georgia versus Faust trial, that is a proper, genuine clusterfuck. For example, just to break things off here, the defendant is black. The evidence that was supposed to be in these evidence bags were Caucasian pubic hair, and it's gone. But that comes after this.
Manning, they've developed a test to find out. And this is why in this...
Hey, it's Credence and Mikey. Hey, first of all, everybody go subscribe to Credence and Mikey. I got they caught the defendant in the Judge Simpson court who had sex on Zoom court. I published a video with the panel with me, Hella, Aussie, and Dali when we reacted to their video. So thank you, Credence and Mikey, for catching that. It was amazing. Everybody go subscribe to Credence and Mikey. Thank you so much. It was an amazing video. All right, let's go back to this. And yeah, folks, hit the thumbs up, hit the subscribe. This guy wants to relocate to the United States. In order to do that, I need views, I need ad revenue, I need cash. All right, to relocate from over here to the land of the free.
Case, we had two voir dires. We had the pre-screening process and then the actual voir dire, which is, I mean, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool has would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge, or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And all of these jurors, Mr. Adelson agreed to.
Could you address, preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error, because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to a impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing.
I think his argument is that the media saturation implicitly biased the jurors. I think is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial, and he's pointing to the 2 jurors who did in fact lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. this court should not presume error. And Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice. And if there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same.
Yeah. When it comes to, Tallahassee by American standards is quite small. By the rest of the world standards, it's medium-sized. Medium. In some countries that would be a large city. People. Not everybody watches true crime or court TV or law and crime. They read the papers every once in a while. And after a few years, people who then were maybe in their teens to 20s are now, when it happened, are now in the 30s, 40s, which means the next generation who is now growing up probably have never heard of the case. I will give you an example of how people of my generation, the generation younger than me, and even the next generation younger than me, everybody here knows a few Elvis songs. You go to a teenager today and ask him, what's your favorite Elvis song? Chances are they will say, who's Elvis? Because the next generation have their own issues, have their own popularity contest, have their own opinions. How infuriating the Dan Markel murder was, it's over a decade ago. And between the original killers trial, the Katie trial, and Charlie's trial, and then Wendy's trial. Wendy's trial had a third of the views as Charlie's trial had, because people are moving on. So now if Charlie gets a retrial, it will probably be in front of jurors that have never heard of the case.
Situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's the, when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed,
Oh, by the way, this might be a longer stream because I just found out that Laura Owens, the serial pregnancy scammer, is going after content creators. She has filed injunctions, at least one, against by comparison, tiny content creator in order to try to make us go silent. So we'll listen to this. We will go through the Faust. And if I have time, we will go through the next with the Laura Owens, new Laura Owens stuff.
But whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried, but does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markell's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with these Lords of Chaos group. I agree with you, Your Honor, that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that he could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case. And at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or sort of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking about
affidavits.
the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue? Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing? In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if you file it before, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case, it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is, a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been the, if there were any relevant. I argue that even these weren't relevant, but the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes, sir.
I'm not going to allow you. I think that would harm yourself if you admitted that. So I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that. And because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not be, judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markell.
May it please the court. I'll begin by briefly addressing Claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and say—
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. And number two, my client would be— I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, oh, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this. He didn't hire these people. He's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it. That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury. So is that the correct standard to be used in striking an entire panel?
I think that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke. not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into my, over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case. Thank
Counsel,
you.
my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case. And that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor. And it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case, even though the court specifically said, don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All right. Again, I am thoroughly impressed by the defense attorney. How he handled himself under pressure. Do I believe this will rise to Charlie getting a new trial? No, I don't think so. But I wouldn't mind, because I would love to see Charlie Adelson get his case a retrial after all that happened in Wendy's trial, where she threw him under the bus. Yeah, I would really, really like to see a retrial. And also, it opens up for plea deals. Charlie might say, hey, I will plead to manslaughter, and I will give you Wendy. Yeah, Donna, Wendy, whatever's. Sorry. Yeah, Donna threw him under the bus. He might return the favor now, win the retrial. All right, folks. This was Charlie Adelson appeal. Now let's talk about the Faust trial. It is a 2001 case, cold case, where after 23 years, in 2024, they arrested Mr. Faust. Because new development in DNA testing, they found that his DNA was inside her, the victim. So they charged him with 4 or 5 felony murder counts. They charged him with rape, backdoor rape, arson, and robbery or breaking an entry. And it all sounds really, really bad for Mr. Faust. And then trial started. And we found out that the victim had a boyfriend who claimed he had not seen her for at least 10 days. And then with the DNA testing, his DNA, liquid DNA, was inside her. Liquid DNA inside a person is more or less washed out 3 to 5 days later. And he says, never saw her for the 10 days at least. So he lied. And also the defense attorney in the opening statement showed this picture. This is the victim's boyfriend's hands 2 days after she was found dead. Wouldn't that, with the DNA and him lying to the investigators for over 20 years, rise to some suspicion? Apparently not. This is just coinkydonk, coincidence. The defendant is black, her ex-boyfriend or her then boyfriend is white. You don't know if that is an argument the defense will bring. Yeah, and according to the defense opening statement, the boyfriend with these injured hands, it took the lead investigator hours of interrogation and suggestion that he should change his mind before he said, yeah, we might have met up on that Sunday before. That's 6 days. Still, now all of a sudden, within the realm of possibilities that his DNA might have been there. Here's the thing. The defendant is charged with backdoor rape. The defendant's liquid DNA is not in her backdoor. Her boyfriend's liquid DNA is in her backdoor. And according to the state's medical examiner back then, it's clear that she was raped due to the injuries. But they don't charge the boyfriend with provable injuries. The victim was brutally beaten. Backdoor raped. But he's not charged. The defendant is. Now, let's go and listen to the cross-examination of a witness that showed up to court. Well, let's just say the state entered evidence bags into evidence, claiming hair, pubic hair, and stuff. And the defense made him open those evidence bags. Now this has
Ladies and gentlemen, you may be seated.
really
Mr. Cruz, cross-examination.
bad.
Good afternoon, Lieutenant Lidow.
Good afternoon, sir.
I would like to follow up with you on some things that the state discussed with you. I'd like to show you State's Exhibit 37. Your Honor, is it okay if I approach the witness?
Yes, sir.
And you have continuing freedom to walk around the courtroom. You don't have to ask.
Now, we've established that you recognize that photo as an aerial view of the Deer Park community. Is that correct?
Yes, sir, that's correct.
Okay. And I would like to also show you what's marked as Defense Exhibit 12, 13, 14, and 15. And let the record reflect, I may have skipped 9, 10, and 11. These are marked. Let the record reflect that I'm showing the state said as it is. Lieutenant Liddell, take your time, look at those photographs. Once you've had opportunity to look at those photographs, just please look up. You recognize Defense Exhibit 12 through 15, if I have my numbering correct, as aerial views of the Deer Park community. Is that correct?
Yes, sir, they are.
Okay, and they're aerial views from different angles. Is that correct?
Yes, that's correct.
Are those photographs fan accurate depictions of Deer Park and the surrounding area as you know it?
Yes, sir, they are.
Thank you. Have those photographs been altered in any way to your knowledge?
They don't appear to be, no.
Yes, sir. Your Honor, I would move to admit Defense Exhibit 12 through 15 into evidence.
Any objection?
No objection, Judge.
They are admitted.
Do you want 37 back?
See if I no sorry, no closed captions on this stream.
I'd also like
Sorry.
to show you State's Exhibit 47. We've established that you recognize State's Exhibit 47. Is it okay if I approach you, sir?
Yes, sir.
I'll raise the
Yes,
volume
you recognize that photograph. Is that correct?
as much as I can.
I'd like to show you. Court's indulgence, Your Honor. I'd like to show you what has been marked as Defense Exhibit 9. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 9.
No objection, Your Honor.
Go ahead. It's fine.
Yeah, I won't be startled.
So I handed you the State's Exhibit and I handed you Defense Exhibit 9. Would you agree that Defense Exhibit 9 is a close-up of the window depicted in State's Exhibit, I believe 27, if I'm not mistaken. I may have that number wrong. 47, please forgive me.
Yes, sir. You're correct.
And do you recognize that photo?
Yes, sir. It's the photograph showing the window adjacent to the rear entrance or exit, however you want to look at, to the apartment.
Yes, sir. Has that, to your knowledge, or would you have any reason to disagree that that photo has not been altered in any way?
I would agree.
Your Honor, I would move to admit Defense Exhibit 9 into evidence.
Any objection?
No objection, Judge.
Admitted.
Yes, ma'am. And I would ask for permission to publish Defense Exhibit 9 and State's Exhibit 47 to the jury. Thank you.
Reminder, hit the thumbs up, do all the YouTuber things. Big Nick here needs the views. Yeah, gloves and scratching your body. And he wipes his nose with the gloves on. Yeah, let's test the DNA of that bag.
I'd like to show you what is being marked as Defense Exhibit 10. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 10.
Absolutely.
Lieutenant Leadall, do you recognize Defense Exhibit 10?
I do.
Okay, and you recognize Defense Exhibit 10 as the back door that's depicted in State's Exhibit 47, is that correct?
Yes, sir, it is.
And it's just a closer up view of said door, is that right?
That's correct.
Would you have any reason to disagree that that photo has not been altered in any way?
It doesn't appear to be altered that I'm aware of.
Yes, sir. Is it a fair and accurate depiction of the back door as you remember it to be?
Yes, sir.
Your Honor, I would move to admit Defense Exhibit 10 into evidence and publish same to the jury.
No objection, Judge.
I have 2 sound boosters on. That's how bad the audio is from this trial. I will lower my microphone so you guys can raise
I'd like
the
to show you what's been
volume.
marked as State's Exhibit 71.
There, I lowered my volume so you can raise the overall volume yourselves.
In regards to State's Exhibit 71, I believe we saw a prior photo of material from the ceiling that was on top of Ms. Baker and on top of that item there. Is that correct?
Yes, sir.
Okay. And just to make the record clear, the item that I'm speaking of is the power transformer. Where the power transformer is located, once that debris was moved, is that the place that you found the power transformer located?
Yes.
Okay. Your Honor, I would ask for permission to publish State's Exhibit 27 to members of the jury.
That was already admitted, correct?
It was.
Thank you.
Thank you. And we've already established that on January 19th, 2001, you went to Ms. Baker's home and you had opportunity to view her body, correct? Do you agree?
Yes, sir.
In regards to the evidence located on and around Ms. Baker's body, there were hairs collected from Ms. Baker's left hand. Is that correct?
Yes, sir.
There were hairs collected from Ms. Baker's body. Is that right?
That's correct.
There was also a hair collected from Ms. Baker's buttocks. Is that right?
That's correct.
And I'm going to get you another pair of gloves.
No, I'm good.
Really?
Give me 1 second. Court's indulgence.
The defense attorney offered this jackass, hey, change your gloves. And this jackass says, no, I'm good. No, you're fucking not. You wiped your nose with gloves, with the gloves on, who you now are going to touch evidence with. You idiot. Now I put poll up. What do you think the evidence bags will have in them? You have 3 alternatives. The evidence, dust bunnies, nothing, the bags are empty.
All right, I'd like to show you what's been previously admitted as State's Exhibit 89, which contains a envelope enclosed, documented as item number 8, hair from buttocks. Do you recognize that?
Yes.
I'm going to hand you a pair of
Sealed.
scissors. I would like to
Sealed evidence bag.
open item number 8 that was within State's Exhibit 89. And I provided you a paper towel for the hair.
Okay.
Now, the paper towel is because they have to shake the hair out on the paper towel so it can be seen. standard practice. Don't blow into it, you jackass.
There is no hair in it.
There is no hair in the sealed evidence bag who has the text hair from buttocks. No hair in the sealed evidence bag.
Can you repeat that?
There is no hair inside it.
Thank you.
I'm gonna place this back in the envelope where I cut it open.
Yeah, it's almost as if he knew that he didn't need gloves. I remind you, folks, this is evidence the state submitted as evidence in this fucking trial. And the evidence is gone.
I'd like to show you what's previously been admitted as State's Exhibit 88.
Another
Inside
sealed
State's
envelope.
Exhibit 88, there's an item, there's an envelope marked number 9, hair from torso area of victim. Are you okay with opening this for me, sir?
There's no hair inside here. There's no hair inside here.
There's no hair inside that evidence bag as well. No hair.
Can I take a break for a second? Bathroom break, if it's okay.
Yes, you can. Ladies and gentlemen, I'm going to ask you to go into the jury room for a couple of moments. Please don't discuss the case.
Yeah. Let's.
Lieutenant Leow, did you collect hairs and put them in those envelopes?
Yes,
Okay, so at one point in time, there would have been hair in those envelopes. Is that correct?
that's correct.
Thank you, sir.
Sluthy, this trial is ongoing. This happened today
Right.
at trial.
I'd like to show you what's been previously admitted as State's Exhibit 90, which is hair from left hand of victim. And inside State's Exhibit 90 is a white envelope marked number 10 with a description of hair from left hand of victim. May I approach? Can you open this for me? Lieutenant Leadoff is looking at that exhibit. I would like to mark empty envelope number 8, which is the envelope that was supposed to contain the hair from Ms. Baker's buttocks, as defense exhibit 11.
Are we about to be 3 out of 3? Let's find out.
Which I'll separate from State's, I think 27. Sorry, which I separated from State's 89.
you asking it to be readmitted, or are you just putting a defense number on the already admitted exhibit? You want it on the envelope? Okay, and it's number 11. All right. So any objection, Mr. Yeoman-Chili?
I don't have an objection. I think the original larger envelope and its contents have already been admitted. However, I don't have any objection to
All right.
labeling the interior envelope.
I will admit it in that manner.
Yes, ma'am. Also, the envelope that was in State's Exhibit 88, which is the empty envelope containing, well, that would have contained hair from the torso of the victim. I am admitting this as Defense Exhibit 16, Your Honor.
All right, Mr. Yeoman-Chili, any response?
Just the same response, Your Honor.
All right, I will admit it. Okay, it has been, the whole package has been admitted as State's Exhibit, but I will admit it as Defense 16 in this manner without objection.
Lieutenant Liedall, can you tell me the number of hairs that were in State's Exhibit 90?
From this, none. There was 0 in here.
There are no hairs in State's Exhibit 90?
That's correct.
3 out of 3. The hair from buttocks, hair in hand, hair on torso that the state submitted as evidence, not in the evidence bags. Now, folks, how will the state rectify this? Well, they can always claim the samples were destroyed in testing. Well, that makes it impossible for the defense to test it themselves. Now, these hairs are supposedly Caucasian hair. Mr. Faust is not Caucasian. So you have hair in between her fingers, the victim, on her back door, on her chest, Caucasian hair. You have her boyfriend, remember the boyfriend? Whose hands looked like this 2 days after she was found dead. Her Caucasian boyfriend. He's not on trial. The black dude is. Let's continue. Oh, Nick, whatever, could anything else have gone wrong with this? Let's just wait and see.
Did you put hairs in the envelope when you sealed it up?
Yes.
When he sealed them up, signed the envelopes, there was hair there. Again, the state might say, well, we took them out, tested, and resealed it as empty. They didn't say that on direct. Why is this even a trial?
Your Honor, I would like to mark as Defense Exhibit 17, the empty envelope that would have contained the hair from the left hand of Ms. Tara Baker.
Any objection, Mr. Yeoman-Chili?
No objection, Judge.
All right, I will admit it in the same manner as before without objection.
In regards to your observation of Ms. Baker's home, is it fair to say that you determined that Ms. Baker's front door was deadbolt locked before it was opened by firefighters?
It appears that way, yes.
You would agree that there were multiple bedrooms in Ms. Baker's home, correct?
That's correct.
And they belonged to Ms. Baker's roommates, Ms. Ashley, at the time, Ms. Ashley Peavy, now Mrs. Ashley Peavy Hall, and at the time, Ms. Valerie Lowe, now Dr. Valerie, excuse me. At the time, Ms. Valerie Lane, now Dr. Valerie Lowe. Is that correct?
That's correct.
Based on your observations, none of the drawers in Ms. Lane's room appeared to be disturbed.
That's correct.
Based on your observations, none of the drawers in Ms. Peavy's room appeared to be disturbed.
That's correct.
Would you agree that Ms. Lang and Ms. Peavy had jewelry boxes, computers, and other accessories in plain view within the home?
That's correct. There was.
And of course, I'm sure we agree on this, none of those items were taken from the home.
That's correct.
You also had the opportunity to walk through the living room and the common area of the home. Is that correct?
I did, yes.
Would you agree with the statement that nothing was stolen, that nothing appeared to be stolen from the living room or common area of the home?
I can't say that with any certainty since I don't live there and don't know what is actually there, but there were items still present.
Do you recall writing a report dated January 21st, 2001?
I do.
You have a copy of that report up there with you?
I do, yes.
Can you turn to page 3 of 11?
Okay.
Can you read the 4th sentence? And the first sentence ends in burglaries. So the first sentence you'll see is commonly removed in burglaries. Can you read the 3rd sentence from that period?
Some items have been moved after the fire, indicated from markings on the floor.
Read the sentence before that one.
The living room and common area of the residence contained furniture and a television/VCR.
And can you read the next sentence?
Nothing appeared to be disturbed prior to the fire.
Thank you.
Yeah, and Mr. Faust is accused and charged with robbery. There's no evidence whatsoever that anything was taken from the apartment prior to the fire. No evidence whatsoever. The breaking and entering and robbery, that is under the assumption that Mr. Faust is the person who actually went in there and did all these things. But there's no actual evidence for it presented by the state so far.
So it's fair to say that nothing appeared to be disturbed in the living room and common area.
That's correct.
Now, you also then had opportunity, and I believe I provided you with an exhibit, the state provided you with an exhibit as well, but we can agree that you had an opportunity to examine the window in the kitchen area, right?
Yes, sir, I did.
Now, you would agree that the blinds were down on both the window on the door as well as the window in the dining area?
Yes, sir, they were.
Thank you. I believe you discussed this with the state, but during your examination of the home, you learned that several items had wipe marks. Is that right?
The door area, the front door near the peephole, and other areas, white marks probably from just general cleaning throughout the course of that door being there. I can't say when the white marks occurred, but there were marks there that were picked up when I put fingerprint powder to those surfaces.
So is it fair to say that we don't know if the white marks happened after Ms. Baker's murder, nor do we know if the white marks happened before Ms. Baker's murder?
That would be correct, yes.
And those white marks were present on the stove. Would you agree with that?
I don't recall if there was any on the stove.
Sure. Can you turn to page 9 of 11 of your January 21st, 2001 report, please? And if you will go to the second paragraph, in the 4th sentence from the bottom, that starts with "in processing the front door." Can you read that, please?
In processing the front door, stove, and window sill, markings similar to one wipes the surface with a rag were found. The markings on the front of the door were consistent with a person looking out the peephole and placing left hand on the door. The white mark where the left hand would have been as well as along the door edge. White marks were also found on the window sill in the dining area.
Thank you. Now, when Ms. Baker was found, you would agree that she was completely naked?
That's correct.
There were no clothes around her that were notated in your report. Is that right?
That's correct.
And a towel was not found near her body?
That's correct.
Your Honor, I don't have any more questions for Lieutenant Leadall. Thank you so much for your service. Those are my questions.
Any redirect?
Let's see here. Let's listen to, because now they're having a discussion.
Mr. Yellamachilli.
Briefly, Judge, Lieutenant Leadall, as it relates to the hairs you collected, did you package those hairs?
I did.
Did you send them to the GBI?
Yes, sir, I did.
Okay. And that would have been for some kind of analysis or testing possibilities. Is that right?
That's correct.
Do you have any idea what the GBI did with them once they received them?
I do not.
Does not have any other?
Yeah, that's their. Hey, you did send them off for testing. Yeah, but then these envelopes should have been opened. Hair that wasn't part of the test back in these envelopes, then put in another envelope to then be sealed with the agencies, the test agencies' initials and stamped. They didn't. There's only this one with the envelopes still sealed with his markings saying, I sealed this evidence. For fuck's sake.
Other questions for Lieutenant Leadall? Thank you.
Any recross, Mr. Cruz?
No, ma'am, but I do have a motion.
All right. Do you, all right,
Or we could approach, if you don't want to send the jury out, we could approach it.
all right. Okay, that's fine. I mean, I may do that anyway, but come on up, that's fine.
Okay. She will send the jury out. Oh, come on. Stop buffering. Stop buffering. Seriously. Stop freaking buffering. This is stupid. Why are you buffering? For the love of... Oh, I hate this. Okay, there we go.
Here's your motion. Go ahead, sir.
I would just like to renew my motion in regards to, and I'll say motion to eliminate, to admission of testimony that the oral swab B is a vaginal swab. The additional information that I'm providing to the court is consistent with our prior argument that regarding the collection of that swabbing and the markings of that swabbing, and what Dr. Falzone testified to in regards to the procedure, as well as the supervision of making sure items are properly marked and properly identified. As the number court saw, we just had, I believe it's 3 envelopes. One was supposed to contain, it was marked to contain hair from Ms. Baker's hand. And we heard testimony from the Honorable Lieutenant Leadall that he collected it, he put it in the envelope. It is now missing. We also had a hair that was identified that was on Ms. Baker's butt that the Honorable Lieutenant Leadall stated that he put in the envelope. It is now missing. And we also heard about the hair, you also heard testimony about the hair that was on Ms. Baker's chest that the Honorable Lieutenant Leadall secured, packaged up. It is now missing. I would ask the Honorable Court to consider that in regards to our argument regarding the oral swabs. And 23 years later, the state is going to attempt to introduce testimony that these oral swabbings are now vaginal swabs. Thank you for hearing me out, Your Honor.
Thank you.
Yeah. The markings on these swabs was oral swabs. The state now claims, no, they are vaginal swabs. Because apparently they don't have a fucking clue what evidence is in which evidence bag, if there is evidence in the actual evidence bags. This is Georgia versus Edric Faust. The victim is Tara Louise Baker, who was brutally murdered in 2001. I'm just going to try to find... Hold on here. Well, we can show this again. This is her boyfriend's hands 2 days after she was found dead. His DNA, liquid DNA, is in her. In her back door, which the medical examiner says the injuries says grape. And this guy's liquid DNA is in there. A guy who lied for 23, 24 years about the last time he saw her. But they charge the black guy. All right, that I'm going to save the Laura Owens stuff for Friday, because as it seems, the person that Laura Owens has filed an injunction against will have a fundraiser for his. He now has to hire an attorney. So he will create a fundraiser for the costs, which means Friday, Slightly Buzzed Friday stream will be a fundraising stream. So here we go again. Laura freaking Owens. Laura is charged with 14 felonies, and she still tries to ruin people's lives, this time just for reporting about the case. I will be sending you over to Laura Nighty, because at 9 p.m. Eastern Time, she will talk about this new injunction by Laura Owens. I will wait until Friday for a fundraising stream. So we can get and it is, let's see, it is this. Let me show you. This guy. This is the guy she filed an injunction against. He has just over 1,000 subscribers. She goes after small content creators in hopes that they will stop talking about her. She hasn't gone after Lauren. She hasn't gone after me. She focuses on small content creators. Because in my case, if she has an attorney, if Mr. Gene Drass is behind this pile of garbage, first of all, they know they can't touch me. I'm not in the United States. If they want to file an injunction, they have to find an attorney that is prepared to take this to Swedish courts. And let me tell you, international injunctions are fucking expensive. And Laura Owens is broke. So, Friday, Slightly Buzzed Friday show, starting 5 p.m. I will hold a fundraiser. So, Hey Rob can get his legal costs covered. 9 p.m. Eastern Time, in an hour and a half, Laura Nighty will talk about Laura Owens going after Hey Rob. But that is all I had for you, folks. Thank you. Thank you for allowing me to do this. Thank you for doing all the likes, doing all the subscribes, helping me in my quest to relocate to the United States eventually. Because even though there are probably 100 reasons for me to stay in Sweden, we don't have a First Amendment. We do not have freedom of speech. That is mainly why you don't hear me cover much of local cases, because I run the risk of defamation. Over here, defamation is a criminal offense. Over here, truth is not an absolute defense against defamation. We don't have a First Amendment. You have. Folks, again, thank you so much from me and Mr. Jingles, who is over there somewhere. I will see you in the next stream or video. All right? You all have a good one. Bye-bye.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather.